It's 2 p.m. Geneva time. We have now all the speakers in the room, so we will now be officially launching this event, which is taking place in the margins of the 60th session of the Human Rights Council that is currently ongoing here at Palais des Nations in Geneva. This event will be providing a platform for dialogue on advancing environmental rights in the ASEAN within the context of the global legal and policy developments. The event will be moderated by Matthew Baird, who is the director of the ASEAN Research Institute for Environmental Law. It's a real pleasure to have many friends who are not from Geneva here in the room and joining us also online. Thank you all for being here. And without further ado, though we are still waiting here in Geneva for a few more people in the room, Matthew, you have the floor.
Thank you very much indeed, Diana, and welcome everybody. I'm also very happy to be here and to be at this side event for a very, very interesting time in environmental law and human rights. We've had some amazing successes recently on environmental law and human rights law, and especially the idea of environmental rights. So we're going to explore a bit of that over the next half an hour and then have some time for moderated questions. But I first of all should like to thank Diana and the Geneva Environment Network for hosting us here. It is a bit of a rainy day, but hopefully the rain will pass and sunshine shall emerge, which is sort of a little bit of a metaphor for how we think about environmental rights. And we're going to talk about environmental rights in ASEAN in a little bit, and also some of the reflections on the context of the International Court of Justice advisory opinion, which I think has been an enormous ray of sunshine for us. And I think going forward, we'll find some really interesting legal and human rights opportunities. We have a great panel. I'm going to just quickly introduce the three speakers that we have. We have on my right, Rocky Guzman, who is the Deputy Director of the Asian Research Institute for Environmental Law. He's an environmental lawyer and policy specialist with an extensive background in ocean issues and a graduate of the Rhodes Academy. He has worked on and conducted research on topics from fisheries management and plastic pollution to marine conservation and strengthening the rule of environmental law. He was previously a campaigner of Oceana in the Philippines and has involved in a variety of different environmental issues for Southeast Asia with the Asian Development Bank, the UN Environment Programme, and the Sustainable Ocean Alliance. Rocky obtained his law and political science degree from the University of the Philippines and his Master of Environmental Policy from Duke University. To my left is an amazing and extraordinary activist and lawyer, Nicole Ponce, who's the Global Advocacy Lead for the World's Youth for Climate Justice. And Nicole is an environmental and human rights lawyer advocate from the Philippines with a strong interest in the intersection of law, science and policy. She holds degrees in both political science and law, has a background in research and is admitted to the Philippine Bar. She currently serves as the Global Advocacy Lead and formerly as the Asia Front Convener of the World's Youth for Climate Justice, ICJ, which she also co-founded. In addition, she works at the Centre National de la Recherche Scientifique, Paris delegation as a research officer. And on the 23rd of July 2025, the Global Youth Movement and the ICJ Advisory Opinion Alliance, led by WYCJ and PSIFC, which is Pacific Island Students Fighting Climate Change, obtained the unanimous decision from the International Court of Justice on its request for an advisory opinion on climate change and human rights. And Nicole is going to talk a little bit about some of the issues arising from that. I should, of course, point out that not only did this amazing group of people obtain the advisory opinion on climate change and human rights by bringing it to the International Court of Justice, but they received an extraordinary outpouring of support to ensure that this advisory opinion, one of the few advisory opinions, was referred from the General Assembly of the United Nations to the ICJ, and it was referred without dissent. And that was, as a campaign, an extraordinary achievement that has only been matched, I think, by the extraordinary decision by the justices on the International Court of Justice. And to her left is Max Hahn, who is the co-founder and executive director of Youths United for Earth. And Max was one of the co-founders of YUFE, an award-winning grassroots non-profit mobilising youths for environmental action through storytelling, campaigns and advocacy. Since 2019, youth has reached over 50,000 people, engaged global institutions, including the UN, the EU, and Malaysia's central bank, and now advises Malaysia's Environment Ministry. Internationally, Max has advocated for climate justice at the UN, Stanford, Princeton, Oxford, and other international forums, including many where I've been present. He is a contributing author to La La Land, Singapore's Seafood Heritage, a published book examining food heritage and sustainability, and is now, and I like to say that Max puts this sort of as his least achievement, is a Rhodes Scholar at Oxford University for Malaysia. So currently, Max has been involved with Rocky and Ariel and a number of groups in drafting Southeast ASEAN's first environmental rights declaration. And he was recognised for this work. He was awarded the UN Messenger of Peace, the Dr. Jane Goodall, and named by Prestige as Malaysia's 40th most successful, innovative and influential people. He has received the Princess Diana Award, Tatler's Gen T Leader of Tomorrow, and the North American Association for Environmental Education's 30 Under 30. He's also a National Geographic Young Explorer and the first Southeast Asian to be made a future Nobel Laureate Scholar. So we have an exceptional panel, great presentations that we'll hear first from Rocky about the introduction to the draft ASEAN Declaration, and then looking at lessons from the ICJ and also lessons from the ICJA process, the ASEAN Intergovernmental Commission on Human Rights. And so before I ask Rocky to kick off the discussion, I just want to put this in a bit of context. A number of years ago, the ASEAN Intergovernmental Commission on Human Rights was looking at the idea of developing a framework on environmental rights in ASEAN. ASEAN is the 10-member bloc, 680 million members, one of the fastest growing economies, one of the greatest biodiversity, the mega diverse continents in the region, in the world, but also some of the greatest threats, both to environment and also threats to human rights and environmental defenders. The ASEAN Intergovernmental Commission on Human Rights, led by Professor Amara Pongsavich, who was the then Thailand representative to ICJA, developed the idea of putting together a framework agreement on environmental rights that would look at environmental rights as they were being developed throughout the world, partly inspired by the recently approved and adopted Escazú Agreement, but also recognising the enormous contribution that the Aarhus Convention has made to environmental rights. So the ASEAN Declaration, of which Ariel was a contributing partner and the initial drafter, came together for a working group over a period of 2.5 years, looking at a variety of issues, procedural rights and substantive rights to promote environmental rights in ASEAN. That has finished, and we hope that in October, the ASEAN Summit in Malaysia, under the leadership of Malaysia, will finally approve some form of declaration on environmental rights. So to introduce that and to see where we go from there, I'd like to ask Rocky to start his presentation.
Thank you very much, Matthew, for that kind introduction. Of course, Diana and the Geneva Environment Network for hosting us here in Geneva. I am honored to kick off this conversation here at the occasion of the 60th Human Rights Council session here in Geneva. And I'll be presenting on some updates, developments, and ways forward in what I think are exciting developments happening on the other side of the world in Southeast Asia in this presentation towards a regional framework on environmental rights, the case for ASEAN. So as I've said, these are very exciting developments, and I'm speaking in my capacity in Ariel as one of the ex-working group members of the ASEAN Environmental Rights Framework, which for 3 years have developed the first regional framework for environmental rights that would hopefully lead to the first instrument called the draft ASEAN Declaration on the Right to a Safe, Clean, Healthy, and Sustainable Environment in ASEAN. So that's the context where I'll be speaking. So next. So before I start, it will be really helpful to have some context of what's happening in Southeast Asia and the ASEAN region. So we take a look back first at some of the hard and fast facts, some statistics and what's happening on the ground in ASEAN. So over most part of the last decade, we have here statistics from the Global Witness reports from 2012 to 2021, there has been a lot of killings and attacks against environmental human rights defenders in the region. Out of around 1,700, 318 were perpetrated in Southeast Asia. A large chunk has been perpetrated in the Philippines, where I'm from, but there are also a lot of cases in other countries such as Indonesia, Thailand, Cambodia, and so on. Now, this statistics alone just looks at the killings in Southeast Asia, but it also has a lot of other attacks, including on enforced disappearances, vilification, harassment, physical violence, and all those. Now, some of these, many of these cases have also been state perpetrated, and a lot of cases have also been perpetrated against marginalized sectors, particularly for indigenous peoples, in logging issues, and so on. Now, this is the context where I'd like to start, or whereby we started the conversation on developing this regional environmental rights framework to provide the protection to address the issues that are hounding the plight of environmental human rights defenders in ASEAN. Now, as Matthew mentioned, we have been involved heavily over the past 3 to 5 years over the development of this regional environmental rights framework. But a lot of the conversations have happened even before that. But the initiative has been led by the ASEAN Intergovernmental Commission of Human Rights, or what they call ICHAR, which is the main regional human rights body of ASEAN. And when we started the process, we sought to bring together existing ASEAN commitments over different regional instruments, as well as various international obligations in a comprehensive and a cohesive manner. Now, as the process started, it was resolved that the form and content would be determined through collaborative discussion among different stakeholders by the constitution of what we call the ASEAN Environmental Rights Working Group, which is composed of ASEAN governments, as well as other stakeholders, CSOs, including us, Matthew, myself, and Max were part of that, as well as other bodies and stakeholders. Now, this was to achieve a holistic approach, and that would enhance the coherence of the regional framework, growing from the issues from different stakeholder groups in the region. Now, the framework, as was then conceived, would draw international experiences with other international environmental rights agreements, including regional frameworks that would summarize possibilities for both substantive elements as well as procedural elements. I'll be discussing more. So when we were thinking about this, we were starting with the development. We conceived at the working group level to have this framework cover both substantive elements and procedural elements. Substantive elements, the premise being that human rights is interdependent to environmental protection, and it's important to have everyone and anyone must have the right to a healthy, sustainable environment, which is necessary to achieve, enjoy a vast range of human rights. Now, it draws from international developments, particularly on the UNGA and UN Human Rights Council resolutions, prescribing the right to a clean, healthy, and sustainable environment. But even before then, that was 2022, even before then in 2012, ASEAN already had a framework in place. That was the ASEAN Human Rights Declaration, and it prescribes that everyone has a right to a safe, clean, and sustainable environment. So taken together, these regional and global developments, the ASEAN already had a framework to have the right to a clean, safe, healthy, and sustainable environment. And this is composed, of these substantive rights that were elaborated further by NOX, the former Special Rapporteur on Human Rights and Environment, and it also included some other issues that are very pertinent to the region, including oceans, the marine environment, and coastal zones. So that's where we started also discussion on the substantive elements. On the procedural elements, it draws from international developments, particularly getting the basis on the Rio Declaration in 1992, which provides for the 3 access rights: access to information, public participation in decision-making for environmental matters, as well as access to justice and effective remedy. It also draws from the experience of recent developments at the regional level, including the establishment of a safe and enabling environment for environmental and human rights defenders, or EHRDs, to exercise their rights. So taken all together, procedural elements draws from international experiences, the Rio Declaration, regional frameworks, including the Aarhus Convention based in Europe, the SCAZU agreement, which is more recent and has a lot of parallels in what's happening in ASEAN, but also other instruments, including Transboundary EIA with the SPU Convention and SEA, Strategic Environmental Assessment with HEAV Protocol. So these are some of the elements that we have put together as we were developing this environmental rights framework at the ASEAN level, at the working group level. Now, to give just a timeline of what has happened so far, even though the discussion started way before 2022, the formal constitution of the working group happened in 2022. And in 2023, we were given the terms of reference, appointing different stakeholders and government officials, ICHR representatives, to form this ASEAN Environmental Rights Working Group. And for 3 years, from 2022 until 2024, we have held successive environmental rights working group meetings. We have had 5 so far from 2023 until last year, July of 2024. 2024 was the last working group meeting, and it was resolved at that time that we should proceed to the next level and submit the draft declaration to the ICHR level, because there were so many deadlocks in that process already, and it had to go to the next step. Now, as Matthew mentioned, the next step would be that it would the ASEAN leaders would then sign it at the ASEAN Summit, which will be happening next month in October in Kuala Lumpur, as Malaysia is the ASEAN chair. And we hope to have the declaration signed already, a strong and robust declaration signed, and then we can proceed with the next steps, potentially with an implementation plan and a framework plan of action for that process. So this is the timeline. It's been like 4 years coming, but there has also been a number of issues and challenges in the process, and I'll mention some of these broadly, and my colleague Max can tell more about it. But I've mentioned that we, as the working group, had submitted and endorsed a draft declaration to the ASEAN, to the ICHR members for their deliberation. But that draft, mind you, is not a consensus draft, and it was actually fraught with a lot of issues and elements that were not that had not gotten consensus. So that draft had a lot of brackets and alternates, and the main issue was whether it would be a statement of broad principles, as some ICHR representatives and governments wanted, or whether it would be a comprehensive framework discussion, which would cover a lot of issues and elements that were deemed important and issues on the ground for EHRDs, for instance. These includes issues including indigenous peoples and reference to those, EHRDs, environmental impact assessment, and substantive elements. Now, as to stakeholder engagement, there has also been a number of challenges, because there has been a lack of transparency in the process. Throughout the process, there wasn't a lot of touch points where the body and the working group would give or disclose the draft to the public and civil society. There was no structured feedback mechanism, for instance, and it was not clear what the status of drafts and the submissions were. There was also a period of consultation that was provided, but it was only 1 month. So that gave us a lot of issues and challenges, because it was not enough to have these consultations in a meaningful manner in 1 month, and there was no structure in really taking all the feedback that was provided. So there were some of these challenges in this stakeholder engagement. And now, at this point, since the working group has been disbanded since July 2024, the issue is whether representation will still continue, whether ASEAN or ICHR will still continue to engage with CSOs. That's the question. Since we were deactivated, there is no formal touch point with the ASEAN right now, with the CSOs, and that will be a question that we will be seeking to answer in the next steps in this declaration. So I will end here by the implications of the first regional environmental rights framework for ASEAN, by really highlighting that this first global regional initiative would provide the impetus for developing a stronger enabling environment for environmental rights, which recognizes the key pillars of sound environmental governance. We'll look at some of the developments, including the Escazú Agreement, as our inspiration. And with this framework in place, we believe that it would necessitate reforms in policy, regulation, and judicial procedure to uphold environmental rights. And throughout this process, we would like to emphasize that stakeholder engagement and public participation are key to making sure that this would be a strong regional environmental rights framework for ASEAN. So I'll end there, and I'm happy to take more of your questions later on. Thank you very much.
And thank you very much indeed, Rocky. And as Rocky said, there were clearly some challenges within the process. I should also say Rocky has also managed to survive the INC plastics negotiations, so he was doing them at the same time, very much the glutton for punishment. But managed to survive and still be able to smile. So thank you very much indeed, Rocky, for that. So to talk us now through some of the good, the bad, the ugly, and the hopeful is Max. And so Max, the floor is now yours to talk us through some of the issues, and you have 10 minutes as well. So.
Hi everyone, I'm Max Han. I'm a Malaysian climate advocate and also, like Rocky, a member of the working group. And all those titles aside, today I really just come to you as a storyteller. I think in UN spaces like this, we're so used to technical policy discussions that aim to reach the mind. But I think when we talk about human rights, stories reach the heart. And so today I'll try to do both. I will try to reach your mind by giving you an overview of the policy process for ASEAN, but also aim to reach your heart as a vessel for the collective consciousness of those advocating for change in Southeast Asia who have given me permission to share their stories here with you. And so I hope you'll be kind to me as a storyteller as I go through the good, the bad, the ugly, and the hopeful of this policy process. So let's start with the good. So as Rocky said, okay, cool. So as Rocky mentioned, there is the good of the framework, which aims to cover both the substantive and the procedural elements. So essentially the what and the how of environmental rights. And it draws on really front-looking agreements internationally and regionally as well, like the Escazú Agreement. And this is really important for ASEAN. It's really important to remember that ASEAN has almost 10% of the world's population and really a big economy, but most importantly, we're very rich in natural resources. Almost 50% of land is covered by forests. Coral reefs are like 1/3, and we have a lot of precious minerals like tin, nickel, gold, but that also puts us at risk of mining in Indonesia, in the Philippines, in Malaysia. And as we consider the renewables revolution, this is a question that comes into focus a bit more. So how do policies translate on the ground? Rocky has given a lot of facts and figures, but I think it's important to put faces and stories to these numbers because environmental defenders are more than numbers, they're people. This is my good friend, Alap Miraso from the Philippines. She is my friend, but also a community activist, a youth climate activist. But 22 years ago, Alap's dad was abducted. In the Philippines, environmental defense is a very contentious activity. Sometimes activists can be tagged as terrorists and something that's called red tagging. And so Alap's dad was a peasant activist fighting for land rights, but he was kidnapped and in what we call enforced disappearances. And till today, Alap has not met her father. And she knows her father through the work of activism. And she's given me permission to share the story as a reminder that environmental defenders are more than just activists. They're family members, they're fathers, daughters, wives, and it's important to humanize environmental defense. And if you look at all the trends, Philippines obviously stands out, but so do other Southeast Asian nations, which has made Southeast Asia one of the most dangerous regions in the world for environmental activism. And particularly, indigenous people and agricultural workers are most affected. And the state and many businesses have been perpetrators of environmental defense attacks. And the strategies for this have gotten more and more creative. Apart from tagging activists as terrorists, there's also accusing activists of tax evasion and jailing many activists, especially in Vietnam recently as well, and Cambodia increasingly. And amidst all this, there's a lack of policies protecting environmental defenders, which is why this framework is so important. 80% of the killings and threats in Asia are in ASEAN. And I know we talk about protecting the environment and curbing emissions, but I want to flip the narrative for everyone here for a bit. By protecting those who protect the environment, you are also in effect protecting the environment, because humans and environment are very much linked together. And this is a case for protecting environmental human rights defenders. So how does this translate in the policy programs? Unfortunately, this is the part where I call the ugly, because as Rocky said, there were many challenges involved. Particularly transparency. This was a closed door meeting, and as many policy processes go, it is really hard for civil society to have input. And even for consultations that came along, it was very difficult, we were underfunded. A lot of us, the youth movement, a lot of activists, we had to use our per diem for the policy meetings to actually run consultations for hundreds of people that really made up the bulk of the consultations for this process. And even despite this big push for indigenous rights, for environmental human rights defenders that came up in the consultations, a lot of it was pushback. Some policymakers thought the idea of indigenous people as a term was too colonial, and EHRDs as a term that was still contested. And so 19 pages as a start became compressed to 4 pages. So I would wonder if substantive and procedural elements are even still there as what we promised in the good. And just some context on indigenous people, 2/3 of the indigenous people in the world are in Asia, and a huge proportion of that is in Southeast Asia. I cannot speak on behalf of this group, and so I'm bringing a statement here from the Asia Indigenous Peoples Pact about the need for self-identification. It's important to remember that the term indigenous people is an umbrella term, and the ability for them to self-identify is important, and remembering that they are the best environmental stewards for generations and generations to come. And most importantly, they're also victims of the attacks on environmental defenders, which makes the case to protect them even more pertinent. And even when we advocated for them in the room, it was very difficult. We faced a lot of threats, verbal abuse, and intimidation that really held back that process. This is a quote from one of the indigenous representatives who fought back to protect the rights of them. And even though it still became bracketed in the end, it was a very long, emotionally painful process. And even so, it got so bad at one point that the UN Special Rapporteurs also got involved and had to send a letter to the group to remind everyone what they're fighting for on environmental rights, on indigenous peoples, that was sent to the working group. And ironically, in a framework that's meant to protect environmental defenders, during the drafting period, more attacks and abductions happened. I remember that day in the meeting room when a lot of my UN colleagues were scrambling on their phones, that was pinging and pinging, because even teenagers in Cambodia were arrested for years for environmental activism. And this makes the case really serious on why we need to have this framework and really push this across. And so despite all of that, you have to get really creative in the way that you advocate for change. And so these are some of the strategies that we've really engaged in to really try and bring hope and push forth in a very difficult process. So one way was to bring in indigenous people in the room. There were no official slots for them, but we actually gave up our badges and brought indigenous people as well. And one thing that surfaced was that some of them were actually older, one of them was the elder. And so in Southeast Asia, respect for the elderly is really important. And that made discussions more civil and people more willing to engage respectfully. And I think there was a huge case on the term being bracketed. We mobilized a lot of civil society groups in ASEAN and submitted a declaration to the working group to be tabled. We raised a lot of media attention internationally, but also locally as well, very strategically as well. And this is important because remember what I said about transparency. A lot of these issues were not reported publicly at all. So a lot of the burden fell on us to report this to everyone. And with that push, more and more people came. Internationally, solidarity was really important in terms of bringing funding for otherwise underfunded process. And most importantly, solidarity on a wider human rights global network. And so having hashed all of this, every story has a lesson. And I think a key lesson here is that, ASEAN is also in this process of decolonization with the case of indigenous people. It is not a metaphor, but as I bring in this quote from Frantz Fanon, it is a historical process. I think when engaging with ASEAN, there is a fear or even trauma of colonization, and that lives on in the legacy of policymaking today, in the refusal to, or perhaps doubt to engage or document Indigenous people in policy. But that's also a step back sometimes when we need that kind of documentation to advance Indigenous rights. Most importantly, we need more leaders who feel pain. That sounds sadomasochistic, but I really mean it, because we need them to feel the pain of those living with the consequences of the decisions they make. But on our end, we also need to make sure that we need to take accountability and hold these leaders accountable, because this is a declaration that will live on for generations and generations for many political cycles. And so with that, I thank you for your solidarity, your kindness, and remember to defend the defenders. Thank you.
Thank you very much, Max. And it would be, one of those interesting things when you're talking about the hopeful to sort of say it's the optimism of youth. But I think it was more than that. It was the optimism of practical and hopeful experience and extraordinary commitment to change. One of the things that we did at the working group was being able to see the ASEAN Youth Forum bring those Indigenous voices of LGBTQ, the marginalised, to the table when the formal processes of the ASEAN Intergovernmental Commission on Human Rights did not allow for that. And I know for both myself and Rocky, this was an extraordinary, powerful demonstration of taking control, if you like, of the process, not waiting for someone to provide permission. And it was really an extraordinary experience. And that leads us on into our final speaker before we open up for questions. And yet again, it was a journey that some would have said was the optimism of youth when some Pacific Island law students decided on a particular project, and that was to ask the International Court of Justice, or to ask the General Assembly of the United Nations to refer an advisory opinion on climate change and liability and obligations under climate change or for climate change to the International Court of Justice. And so the Pacific Island students fighting climate change and also the World Youth for Climate Justice created this extraordinary groundswell of opportunity, asking no one's permission, but seizing that moment and informing the rest of the world that the world's youth were active, engaged, and wanting change. So it's a great pleasure that we finish with Nicole, who will give us a little bit about the advisory opinion of the International Court of Justice. So, Nicole, thank you.
Thank you. Go. I'm happy that works. There you go. So when we decided to start the global campaign to request for an advisory opinion from the International Court of Justice, which also triggered a wave of advisory opinion from the International Tribunal for the Law of the Sea and the Inter-American Court of Human Rights. So the goal was really to provide legal clarity and to push for more ambitious climate action in a global but equally important regional and domestic context. So to finally be able to speak about the ruling of the ICJ on its advisory opinion and its implications for my region, Southeast Asia, it's definitely a high point, because when we started this campaign, the idea was that these are not abstractions. The ICJ advisory opinion is not a silver bullet, but it's supposed to hopefully leverage and amplify the already amazing work that these guys are doing on the ground and so many of our partners and communities. So I'm super excited to see how we can implement and again integrate the ruling of the ICJ and its advisory opinion into these different work streams and these different advocacies and campaigns. I'll start with the question also posted to the ICJ. So, so in July this year, the International Court of Justice delivered a landmark unanimous advisory opinion. I want to emphasize on that at the request of the UN General Assembly. So the court clarified states' obligation under international law in respect of climate change and the legal consequences for breaching them. So this opinion was wide-ranging, interpreting climate treaties, other environmental agreements, and customary international law, with implications across many of international and domestic law and policies. So this truly was a historic win for all of us and a great day for climate justice in general. So because the question put to it by the General Assembly, as the ICJ said, represented more than a legal problem, the concern and existential problem of planetary proportion. And I think that statement alone is really a testament to power of the people that brought this campaign to the International Court of Justice, because the ICJ heard and felt the sentiment of people and communities, and basically the global majority communities, because they acknowledged that these are just not legal problems, these are existential ones. And yeah, as what we've discussed, it was really a watershed moment and a great day for climate justice in general. So the ICJ has given us a lot to work with, and I'm going to do my best. I promise, Matthew, I'll keep it in 10 minutes. Within 10 minutes, I'm going to do my best to discuss the overarching principles. So yeah, when the ICJ also affirmed the need to use the best available science, when we discuss these legal obligations, they require actions to be taken in line with the best available science. And by best available science, it's derived from as represented by IPCC reports. And this should guide states in developing effective climate measures, including deep, rapid, sustained reductions in greenhouse gas emissions and robust adaptation planning. And also, the court confirmed the 1.5 degrees Celsius agreed primary temperature goal under the Paris Agreement. So responsibilities are understood as evolving, right? So while all states are bound by an obligation of due diligence, an extent of their obligations and the assessment of their NDCs and national actions will depend on factors such as historical contributions to cumulative greenhouse gas emissions, and of course, the level of development and national circumstances, which brings into the principle of common but differentiated responsibilities and respective capabilities. And also, the court affirmed again the nationally determined contributions, or NDCs, which states must prepare, communicate, maintain, register, and account for their NDCs. And failure to do so is a breach of legal obligations. And I think this is important to highlight, because for the longest time within the UNFCCC processes, NDCs have become political pledges, but they're not. The court clarified that these are legal binding obligations, and that NDCs must collectively be capable of achieving the temperature goal of limiting global warming to 1.5 degrees. So states therefore have limited discretion, and that their NDCs each must reflect its highest possible ambition, make an adequate contribution, and become more demanding every 5 years, and be informed of the global stock date, which, if we see right now, shows the world is off track. So implementation really is a legally binding duty of conduct of states, which are not required to guarantee result, but must use all reasonable means and best efforts, again, following the standard of due diligence. And the court also included relevant conduct to assess state compliance with their legal obligations. And I think this part is also really important, because it not only limited the source of law to climate treaties or climate treaty frameworks, but also included customary law, which covers fossil fuel production, consumption, subsidies, and licensing. In some circumstances, these may amount to internationally wrongful acts. So all states must provide for and conduct environmental impact assessments. And again, they mentioned customary international law as another source of legal binding obligations, and not just limiting it to the Paris Agreement, for example, because customary law arises from consistent state practice carried out with a sense of legal obligation, and that these legally binding obligations apply to all states, even those outside climate treaties, are those that we draw from them. So there are no excuses now. The era of excuses is over, and the era of accountability starts. And these duties include preventing significant harm to the climate system, due diligence, precaution, regulating both public and private actors, including corporations. That right there, I mean, this duties, in fact, the duties to cooperate for climate protection, these existed even before the Paris Agreement, which relatively is quite new. It was only in 2015, but these are duties that existed way before that, and I think it's important to remember. And another obligation, as source of these state obligations, are international human rights law, which Rocky here, Matthew, and Max has already elaborated earlier on. But I would just like to again share this part this text right here because I think this is very important. It creates that nexus between climate change and human rights, and these are really interdependent. That the environment is the foundation of human life upon which health and well-being of both present and future generations depend. And the court thus considers that the protection of the environment is a precondition for the enjoyment of human rights. And one of those is the right to a clean and healthy and sustainable environment. So the court again reaffirmed that this is a binding legal obligation and accepted that it is a precondition for the enjoyment of many human rights. So what does this advisory opinion mean for Southeast Asia? Matthew here, Rocky, they're already doing the work on the ground. Max, they're already doing they did the work for the ASEAN Declaration because yes, for the longest time, we did not have that environmental rights framework that our friends in the Latin America or the Caribbean had, or even in Europe have. But now, hopefully, the advisory opinion could help bolster that. The thing is that this is also unprecedented territory for many of us. We're still trying to unpack and analyze the implications of the AO and be able to integrate, use it in the different work streams. So this is also an exciting time. But to give you an example, we had a workshop that with some of our community partners in the Philippines and in Asia, together with Greenpeace Asia. And one of the framers, we have an upcoming bill in the Philippines called Klima Bill, which is supposed to address that accountability gap for loss and damage. And the drafters of this bill already mentioned being interested in using the AO and referencing the AO for such bill. And I thought like, wow, that's exactly what we envisioned when we were speaking about this, when we were talking about the AO. That's exactly what we want to see. And we also have colleagues sharing, this is not public knowledge yet, but apparently there are also courts in Brazil who have referenced both the AOs of the ICJ and the Inter-American Court of Human Rights. So that's what we want to do, because if these treaties, if the current, these institutions, these current frameworks were working, we wouldn't have to be here. We didn't have to reach this point, but because the current status quo is not working, we need all these, the legal instruments that we can, we need all of this to amplify each other and amplify the work that's already been done on the ground as well, so ensure that we advance and push for more ambitious climate actions and policies. And thus, will it mean governments in the region will be under pressure to ramp up climate policies? We hope so. And then earlier, just today, we had a workshop with the Youth Negotiators Academy. These are negotiators who are in-depth and are part of the working within the UNFCCC processes and in knee-deep in negotiations. And we just wanted to remind them, because for the longest time, people tend to forget that that there are other sources of legal obligations, not just within the UNFCCC, and to remind them that that exist outside, because every time I've had these conversations with them, they often say, I mean, well, some of these difficult states often say the same recurring arguments every time, that these are voluntary pledges, that they don't accept accountability because they work under the language of the UNFCCC, but there are other sources of obligation, and the ICJ AO has affirmed that. And we're really looking forward to build this capacity amongst youth, but not just in terms of and policies, but also those, again, working on campaigns and advocacies and even litigation, but that will come later on. And we're just excited to see how this can be implemented. Leading up to the COP as well, the court was also very strong in how it says that COP CMA decisions may have legal consequences, and leading up to COP, this will be very useful for those who are engaging in these processes. And that's also part of the conversation we've had with youth negotiators. And looking forward how all of this unfolds. And to continue, exploring pathways to implement and leverage the advisory opinions. So I'll end with that. Thank you, Matthew. I hope I'm on time.
On time. Thank you. Thank you very much. And I think the exciting thing is, as Nicole mentioned, it's not just the advisory opinion of the International Court of Justice. We've had the European Court on Human Rights, we've had the Inter-American Court on Human Rights, we've had the International Tribunal for the Law of the Sea, which was also affirmed by the ICJ. And I have to say, as a lawyer who practiced a lot in environmental law and ran some of the early climate change cases in Australia, and in 2007, Justice Biscoe, when holding the importance of including climate change and impact assessment, said that climate change was a deadly serious business. And amongst the profession, that became a little of a tag and a joke line. I think now, 18 years later, to ensure that the International Court of Justice has made it quite clear that climate change is a deadly serious issue. And now the age of impunity is over. The age of accountability is about to begin. And I think that's where it's going to be extraordinarily exciting to see what we can take forward with the advisory opinion and the extraordinary work from the Pacific Island students fighting climate change and World Youth for Climate World Youth for Climate. Yes. So that's great. Now we have got some time for questions, because one of our commitments with Ariel that all our speakers know is we really do like to ensure that we do get some time for questions and comments. So I'm happy to open it up to the floor for any brave soul to ask a question from the panel.
I'm happy to.
Please.
Guys, hi. I am Francesca Mingrone with the Center for International Environmental Law. Very nice to meet some of you in person and to see again some of you. Welcome back, Nicole. I think maybe just a comment to start, something that all the panelists made quite clear, and it's part of our theory of change, is really this step-by-step approach that whatever achievement or outcome you manage to get in different fora is going to have an impact in other ones. And this kind of puzzle hopefully is going in the right direction. And so it's really uplifting to see to what extent the ASEAN process, the declaration process, is also building on, and hopefully it will be building on different outcomes, whether it's the advisory opinion or the recognition of the right to healthy environment at the Council, at the GA, and so on. So based on that, a question I would have, since my organization and other partners are here in Geneva, is what can we do here to inform the process or like nudge the policymakers in the ASEAN region to get to a final text, to make sure that some important elements are there. So anything that would be helpful from your perspective, whether it's civil society organizations or UN bodies. Here in Geneva, of course, we have the Council that is in session here, but we have treaty bodies, we have special procedures, really a wealth of stakeholders and UN agencies that can have a part in the process. So anything that you think would be helpful for us to keep in mind, I think it would be very useful. Thank you. Thank you very much, Francesca. And also to remind everyone who is in Geneva that we do have a workshop, a webinar, seminar tomorrow at 6 o'clock. With CIL and with the Geneva Environment Network. And of course, CIEL also had an amazing blog during the proceedings and the submissions, which came with a little bit of a cult status amongst all the people that were enjoying watching the proceedings of the ICJ. So Nicole, do you want to start? What can we do in Geneva?
That's a great question. I've listed that to be part of our FAQs. That's a great, but also because we've been from the very beginning, like CL and even the Geneva Environment Network, we've done such great partnerships and collaboration. I guess on my end, it's just to make sure we continue and also tackle some of the questions that when Matthew and I were speaking earlier, tried to nitpick the advisory opinion, because again, it's so good that people are trying to nitpick it now, and then even I guess I'll address some of this misnomer. And for example, probably we'll have more time to discuss about that earlier, but even some states are even saying like, well, the AOs are generally non-binding. So that's always a big one. That's a tough one. And I think that's a conversation that hopefully from our partners we could also address. And because I think it's really a misnomer and it's gonna downplay the strength of the AO because the advisory opinion is not creating the ICJ was not creating new legal obligations, it was merely clarifying, interpreting existing legal obligations. So, and those are binding. So I think that's important to recognize and emphasize. If we could have just help with that, I think that is a recurring discussion that we have with partners, and we always have to address. Otherwise, it gets watered down by because states would be like, well, the ICA doesn't apply, the AO doesn't really apply to us again because this is non-binding. So I think we have to somehow address that conversation.
And maybe Max, you can, I mean, because obviously that was also something that we were heavily involved in the ASEAN ICJ discussions about binding or non-binding.
Mm-hmm.
But I guess it's also, how can those voices that you talked about be brought to these bodies, especially the bodies that are going to be, moving on from the advisory opinion, and implementing some of the ideas.
Yeah, I ended my slide with the word solidarity because I think that is international solidarity is so important. I think in terms of support, I think we need to tread very carefully. One of the lessons I mentioned was that decolonization is not a metaphor. And I believe in ASEAN from a lot of experience and even with civil society, there's a general apprehension when it comes to engaging with foreign networks regarding when we put it into historical context of colonization in the region. And so we need to approach this very carefully. And the way that ASEAN is set up, a lot of funding does come from the EU, but they're also very wary of how much say they can have on their own sovereignty. So when we approach this, I think it's important to make sure that the funding not only goes down to ASEAN governments, but also to the civil society and communities in ASEAN, which really are doing a lot of work and really doing a lot of the advocacy with the right positionality to do it as well. And so I think it's giving these communities funding and resources to do that as well. So that's the first part. The second part, I think, is to be able to connect a lot of communities in Southeast Asia with media. In Southeast Asia, sometimes when I was doing a lot of press release writing and a lot of engagements, some media outlets are very hesitant to report on severe things like human rights issues because they concern state or big businesses. And so, international organizations like Diplomat, or some in Washington DC as well, Monga Bay, that played a really big role in elevating the discussion. So when anyone Googles ASEAN environmental rights, there's at least that presence there. So connecting us the right media organizations, giving us the funding, and when I say funding, it's not just for governments, for communities, but also approaching it with the right way of solidarity and knowing that there's that apprehension and wariness present in the room.
Any other questions?
Few things about this. So that's why it's really important to be like in global conversations like here in the Human Rights Council, because a lot of things are happening in Southeast Asia, and we tend to be in this bubble that we call the ASEAN way, where we have our own standards, the ASEAN standards. And we have to be cognizant that we live in this community where we should align with global standards that are already progressive, right? There has been so many developments over the past years coming from here in Geneva, where the Human Rights Council is, UNHRC resolutions, all these like the implementation of the right to safe, sustainable environment. And we need to have we need to facilitate those touch points that whatever's happening in the global level, global developments should also be aligned with the regional standards that are being set, Sometimes we tend to forget where we are in this whole conversation, but it's important to have these, touch points, especially with ongoing initiatives here in the Human Rights Council, to have that, connection between what's happening at the global level to the regional level. Because my fear really is that whatever we have in the ASEAN level might not be an enhancement of the standards. It could have no effect, or worse, it could even be worse, provide worse standards. We don't want that to happen. That is all for everything that we did. We want to make sure that everything is aligned, global standards, and that it would really enhance the framework at the regional, at the national level in the region.
So I guess also, the question then, and I'll ask you first, Rocky. The focus then has also been on environmental defenders and environmental human rights defenders, however they're defined. There are significant challenges now for lawyers, even for the judiciary in applying some of these things. What are some of what are the steps that we can take, and also using this advisory opinion to strengthen those, the role of lawyers, the role of judges, moving beyond just the extraordinary challenges that the defenders are suffering, but also their representatives.
I can start there with the plight of the lawyers in Southeast Asia. As mentioned, the statistics, the hard facts, and the attacks of environmental defenders includes lawyers here, who are defending the defenders. But what we have, for example, here when we started the process is that we wanted to have strong safeguards on access to justice and access to effective remedy. And we already have a lot of good examples, I would say good practices that we can draw from within the region and also outside. From within the region, we have what I would say progressive rules of procedure for environmental cases. We have remedies that have never been done before, remedies like writs for nature that would stop destructive environmental projects. We have strong anti-SLAPP provisions across different jurisdictions. But we want to draw from these good examples from the region, but also outside, and we want to make it regional standards that will be applied across the region. So right now, when we were doing the working group, was doing the provisions and developing the draft, we wanted to have really strong access to justice provisions, and this includes promoting in the judiciary of each respective jurisdiction strong rules of procedures, for example, as well as strong protections for lawyers as well, and including bar councils and all the actors within the judiciary of each jurisdiction. So these are some of the things that we can look forward to if we have the framework in place.
So in our last few minutes, Nicole, did you want to make an observation? Yeah, how do we bring this forward for lawyers? I mean, again, The Hague's a fairly safe place to be a lawyer. Geneva maybe as well, but maybe not Metro Manila or Zamboangas.
Yeah, we had that. I was recalling that when we were in Bangkok for the ASEAN Environmental Conference, and a friend of ours had to fend off 55, I think it was about 58 SLAPP cases or something like that. Yeah, it was crazy. And those are great. And it's not just in Southeast Asia, it's all over, because we've had that strategy. A few days ago, we had a strategy session, and in Australia, there was a lack of movement lawyers, they say, and I think that's also very important to address. And there were conversations about capacity building, even for lawyers who are able to also, as what Rocky was saying earlier, about being able to create this alignment between the global and regional, because there are international human rights framework, but being able to connect that in a regional and domestic concept, that link, that bridge is also lacking. And there is a need for capacity on that. And I think the institutions here in Geneva would be perfect to provide those capacity building efforts, and hopefully, just being able to connect on a global and regional level these human rights laws.
And Max, I just, as we're finishing up, I mean, the issue of decolonization within Southeast Asia, and, it's interesting that the Escazú agreement within Latin America and the Caribbean picked up and moved in a slightly different way the work of AHUS. Do you think that this ASEAN Environmental Rights Declaration on Environmental Rights has a capacity to strengthen that move, not only in Southeast Asia, but maybe connecting to the Pacific, that are still undergoing a period of decolonization, or maybe even to Africa, where there are now, I think there's has been an initial meeting to sort of talk about a environmental rights declaration for Africa.
Yeah, I mean, the theme for the African Union this year is reparations. So I think there's a lot of interesting discussion in this space. Whatever comes out of ASEAN, I think it has to be ASEAN-led. The ASEAN way is very familiar term in policy making, but the gripe there is that how much of it includes the people of ASEAN. A lot of the meetings are closed doors. Actually, this ASEAN Environmental Rights Declaration is the first step forward for ASEAN because it is one of the first times that they actually invited us as civil society to be inside the room. And it's not like the UN where they give you 2 minutes to speak and then you just gotta make it. Do we actually get a chance to draft and negotiate with the policymakers? Obviously, the intimidation tactics aside, that was a big first step that I'm gonna credit to ASEAN. And I think that's really important when we come to regional policies. And so what we are hoping as well with this ASEAN Environmental Declaration, even though it's non-binding, even though it's just a political declaration, we're hoping that it could spur other regions as well, because we ourselves in ASEAN were inspired by Escazú. And I think the UN has a really important role because they're the ones who have the funding, who convene these spaces to really bridge this together. And also remember that what I said about decolonization, to give people the right positionality to really put these policies in place. Going back to what I said, there's always this wariness of the global north and the UN when it comes to pushing human rights principles. And so I think being smart about how you push it and who you like to push it really matters when policy advocacy in Southeast Asia.
Thank you. I think that brings the very good hour to a close. Diana, did you want to make any final comment as our host?
I just want to thank you. Every time we organize a few events on the ICJ, the Advisory Opinion, and every time we learn something new. And we are very impressed by the energy that you all have. We also screened in Geneva the film where we could see you, Nicole, crying on the film. So we are all very admirative of the work that you are doing. And I think the message clear here is that we need to bring you back on a few things that we will be preparing in the coming months to continue spreading the messages that you are convening today.
So thank you very much, Diana. And anyone in Geneva who would like to come, we are tomorrow. We'll reprise this with a little bit more time at 6:30 p.m. Tuesday at the Maison Internationale des Associations on Rue des Savoies in Geneva, the International House of Association. So that will be an in-person meeting with our great support from CIEL and also the Geneva Environment Network. So thank you. And also World Youth for Climate Justice, Youth United for the Environment, and the Asian Research Institute for Environmental Law. It has been a great pleasure. It's been a great pleasure working with all of this team over the last number of years, and I'm sure there's many more things that we will be doing over the next few. So thank you very much, and thank you for our hosts at the United Nations. Merci beaucoup et au revoir.
On the topic that you were addressing at the beginning, when we were starting, there is in Building A here at Validation, the launch of a report on enforced disappearances in the context of defense of land, natural resources, and the environment, where of course your region is very much highlighted in that report. So it's in Building A, room 9, for all those who are interested, based here, who are here at the Palais. You can join us there. And for those who are still online, the event is going to be streamed on our YouTube channel. Thank you very much.
Thank you. The screen.
Oh, that's
Can we put the screen and get a photo of everyone?
Yeah, you can. So what do we do? I stay here.
Great.
Yes, Patrick.
And then you can walk.
And I do like this.
They'll all go. The screen. Yes. We walk in front of the screen. I think.
There's the 2 bars at the top, which you can push up. Like that.
Sorry.